All right, good morning, everyone. I'm Judge Jackie Powell. This is Magistrate Court. It's for first appearance. Today, we're going to talk about whether I found probable cause and then to talk about release conditions. Today is not your trial date, and so I encourage you not to talk about your case today, especially for those of you who plan on going to trial on your case. In the courtroom, I do have the attorney from the State Attorney's Office, Mr. Eric Linder. I have an attorney from the Public Defender's Office, Mr. Brian Reedy. And I believe over at the main jail, we have the attorney from the Public Defender's Office, Mr. Hector Romero. We also have in the courtroom pretrial supervision representative, and we also have confinement status representative and the clerk of courts. And so all these persons are here to help facilitate the morning. I have read all the probable cause affidavits, and so when I call your name, when you come up, I will let you know whether I have not have determined probable cause. And if your attorney has anything to add to that, then I will also hear that. All right, so before we begin, is there anyone from the jail that they needed to be called out of turn?
And not that I've been told, Judge.
And do we know if we have anyone who needs a Spanish interpreter?
I've been advised that so far we do not.
We do not so far, okay. All right, so starting from the top, Sharnae Clifton.
Good morning, Judge.
Good morning, Mr.
President
Moore. Ms. Clifton, you are before the court this morning for aggravated assault with a deadly weapon, and count 2 is battery causing bodily harm. The court does find probable cause, and I'll hear from your attorney.
Your Honor, state would be seeking a $10,000 bond on count 1, a $5,000 bond on count 2, no victim contact, pretrial release with a GPS monitor. First and foremost, concerned about the level of violence. Appears Miss Clifton brought a knife and a baseball bat into this situation, threatening the victim. I'm also concerned because it appears that Miss Clifton is out on bond right now for grand theft auto, resisting without violence, and DWLS.
Judge, in speaking with Ms. Clifton, she was candid with me. She did advise me that she had that open case in which she has a court date coming up in May. Have spoken to her, though, the $15,000 bond is something that she's not going to be able to afford, nor her family. Now, the alleged victim is her older sister, and she does know that the court is going to order no contact, and she'll be residing separate and apart from her. She'll go and live with her father, who lives in Fort Lauderdale. And that's the person she's actually going to contact to help post her monetary bond. And speaking to her, her father works as a delivery driver. Ms. Clifton is also working, Judge. She works for AMC Movie Theater. She's recently obtained that employment. She's been there for about 1 month, making approximately $8.46 an hour. She has strong ties to the community. She's been here for almost half of her life, Judge. She's graduated locally from Terabella High School, class of 2018. I'm going to be asking the court to consider setting her bond on count 1, $2,500, and on count 2, $1,000, making a total of $3,500. Also, I'm going to be asking the court to sign an order allowing us to photograph the injuries that Ms. Clifton sustained.
All right, the court finding probable cause, count 1, I will impose a bond of $2,500. Count 2, $2,500. No victim contact until further order of the court. Sandra Vallant.
Ms. Valon, come on up here. Judge, she's here at Maine. She's approaching.
Ms. Vallant, you're before the court for misdemeanor capias. on a petty theft charge. The court does find probable cause.
Judge, in speaking Ms. Vallant, she wishes to ask the court if the court would consider resolving this matter today.
And does Ms. Valland have any prior petty theft?
I'd have to check, Your Honor, but it appears that there's restitution in this case. I will not be able to make an offer at this time.
Okay. All right. So, Ms. Vallant, we're not able to resolve the case today. There is restitution that has to be determined.
Judge, if Ms. Vallant has limited contact with the criminal justice system, considering this is nonviolent, she's willing to accept responsibility, would the court consider releasing your ROR so that she could come back to court, and hopefully at that time the state has the restitution amount and they'll be able to work it out at that time?
One moment, Judge. I see no other criminal history, Judge.
All right. I will grant the ROR.
Thank you very much.
All right, Ms. Valland, just before you go,
Yes,
this KPS was issued on March 20th because you did not appear for arraignment. So I would encourage you, one, to make sure that you have the clerk's office has your correct address. Currently, the KPS, the address is 1221 North 59th Avenue, apartment number 2, Hollywood, Florida, 33021. If that is your address, then you need to make sure you check the mail because
I will.
this is not gonna happen a second time.
Thank you, Judge.
All right. Erica Hollander.
Ms. Hollander, come on up, please.
Ms. Hollander, you're before the court for possession of drug paraphernalia. Count 2 is a misdemeanor capias for trespassing. That's a municipal ordinance matter. All right,
Correct, Judge.
the court does find probable cause. What does Ms. Hollander wish to do?
Judge, in speaking Ms. Hollander in reference to the state offense, and I believe her inclination may be the same account too, she wishes to resolve the matter today.
Judge, for the city of Hollywood, they would offer time served on this matter.
Okay,
Offer on count 1 is time served.
all right. So Ms. Hollander,
Judge, she wishes to accept the state's offer.
okay, so Ms. Hollander, you understand everything today?
yes,
All right, please raise your right hand. Do you swear or affirm to tell the truth?
yes, ma'am.
All right, you can put your hand down. Ms. Hollander, do you need any more time to speak with your attorney?
No,
Are you under the influence of drugs or alcohol?
I am not.
Is anyone forcing you to resolve your case?
No, ma'am.
And do you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And do you understand that if you are not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
Okay, what plea do you wish to enter, Ms. Hollander?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given. Your sentence, ma'am, is adjudication and time served.
Thank you.
Good luck, ma'am.
Good luck.
Thank you.
Kathy Akins,
Ms. Akins is in North Broward, Your Honor, and she would like to resolve this matter this morning.
all right. Good morning, Ms. Akins. You are before the court for disorderly conduct and trespassing. The court does find,
I'm sorry, I just wondering what the disorderly conduct was.
they're saying that you were drinking in public And that you were causing disturbance to the persons who were
They
by
have
this
all my
location.
liquor, man. They have all my liquor, right? Ain't none of that open. So how they knew I was drinking if they ain't checked my liquor bottles?
All right.
Ms. Akins, did we not discuss this before court this morning?
No, I didn't talk to you. I talked to someone else.
All right. Well, Judge, perhaps resolving the matter this morning is not in Ms. Akins' best interest. I now have some concerns that, quite
Yes.
frankly, I did not have when I spoke with her earlier.
They said they were gonna drop one of them charges, though.
All right. Ms. Akins, Mr. Reedy, do you believe
gonna-
that this needs to be transferred to?
I would ask that the case be transferred to Judge Lerner Wren.
All right, then we'll sign an order to transfer to Judge Lerner Wren. Ms. Akins, someone will be in touch with you shortly, okay?
All right.
All right.
So just sit down. Let's sit back down.
Yes, you can go back and the deputies will direct you. Christine Gonzalez.
Oh, this is here, our main judge approaching. Municipal ordinance.
All right, Ms. Gonzalez, it's a misdemeanor capious matter on a prostitution charge.
So this is under the city of Hollywood.
All right, it's a municipal ordinance violation, ma'am, so there is an offer for time served on this. Do you wish to accept that to resolve the case?
Yes, ma'am.
All right, Ms. Gonzalez, please raise your right hand. As best you can. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Ms. Gonzalez, you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Okay. What plea do you wish to enter, Ms. Gonzalez?
No contest.
I accept your no contest plea. You find that it's freely and voluntarily given. Your sentence, ma'am, is adjudication and time served. Good luck. Lindsay Kitchen.
North Broward, I believe, Judge.
There's
She is a North Broward judge, and Ms. Kitchen would like to resolve this matter today.
Okay, so Ms. Kitchen, you do have, you're before the court today for two misdemeanor capious matters on, both are prostitution, but one's a city ordinance and one is a state, charge. All right? So your attorney tells me that you wish to resolve your case today?
Yes, ma'am.
All right. State is,
One moment, Judge. Offered being adjudication, time served, HIV test.
okay? I assume it's the.
Same offer, Judge.
Okay. All right, Ms. Kitchen, did you hear that? What the offer
ma'am.
is?
Yes, ma'am.
Is that what you wish to do?
Yes, ma'am.
All right, as best you can, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down.
Thank you.
Ms. Kitchen, is anyone forcing you to resolve your case today?
No, ma'am.
All right, do you need any more time to speak with your attorneys?
No, ma'am.
And are you under the influence of drugs or alcohol?
Ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you're giving up that right.
Yes, ma'am.
And do you understand that if you are not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right, what plea do you wish to enter?
No contest.
Okay, I accept your no contest plea. You find that it's freely and voluntarily given. Your sentence is adjudication and time served. Ma'am, you are required to take a HIV test. You don't have to submit the results. You just have to show that you did take the test. Okay?
Who do I show it to?
Back to the clerk's office, you give them that information.
Yes, ma'am.
All
Thank
right.
you.
Good luck. Yes, thank you.
Got one.
All right, and Sheehy?
She was a medical research. I'm not sure if she's.
And Sheehy is a medical reset? Okay. All right, Lynette Perez. Okay. Emily Montina.
I spoke with Miss Montina earlier. I advised her of her court date tomorrow and the bonds that she has on count 1, 2, and 3. I was subsequently advised by the jail that she did not wish to stick around.
Mr. Reedy, you're having that effect.
I know, I do have that effect on people, Judge.
All right. So Ms. Montina, is charged with grand theft, falsely making credit card, possession of unlawful driver's license, and then she does have 2 violation of probations, which are no bond holds, and she was advised by counsel that she does have court tomorrow, and then the bonds on 1, 2, and 3 will remain. Chantina Dees.
She's approaching, Judge. She's here at Maine.
All right, ma'am, you're before the court for failure to return a rented vehicle. The court does find probable cause. Does anyone wish to be heard as to her bond?
Yes, Judge. I'm going to be asking the court to consider releasing Miss Diaz on straight ROR, or if the court's not comfortable with that, then on pretrial release. She's 45 years old, been here her whole entire life. She's employed basically with the same middle school for the past 14 years, working in the office. She lives in Dania Beach with her brother. She's a registered voter in our community. My understanding is that she has basically a clean record. So considering this a nonviolent offense, that's why I'm asking for that, Judge.
Okay,
She has no criminal history, Judge.
all right, then I'll grant the ROR to Ms. Diaz. And ma'am, you need to make sure that you pay attention to your mail so you know if you have to come back to court, okay? All right,
Good luck, ma'am.
good luck, ma'am. Emily Martinez.
Ms. Martinez is approaching, Judge.
Ms. Martinez, you are before the court for count 1, touch or strike battery. Count 2 is grand theft, and count 3 is resisting recovery of property. The court does find probable cause.
Judge, at this time, nothing to add by the defense. I'm going to be contacting her mother to post her monetary bond.
Okay? All right, then the bond on count 2 is $1,000. Good luck, ma'am. Ebony Ford,
I believe
Paul
it's
Ryan, Your
Ryan.
Honor.
Paul Ryan,
Yes, ma'am.
okay? All right, good morning, Ms. Ford.
Good morning.
You are before the court for 3 counts of aggravated battery with a deadly weapon. The court does find probable cause. And I will hear from the parties as to setting your bond.
Your Honor, I'm going to be asking for bond in the amount of $20,000 per count. Pretrial release with a GPS monitor, no victim contact. I am concerned about these allegations that Ms. Ford struck 3 individuals with her vehicle and pinned them against their own vehicle, while at that time, at least one of them was holding a child in their hands, in their arms.
I understand what the state is saying, Judge, but that's the type of bond that Ms. Ford is not going to be able to make. This incident allegedly took place on November 10th of last year. Ms. Ford is a lifelong resident of South Florida. She lives with her grandmother. She indicated to me that she has had some prior contact with the criminal justice system, that she's been arrested 2 or 3 times in the past. She did indicate to me that she has a business. She's self-employed, selling food. She has about $200 in her bank account, and she pays $500 a month in rent to her grandmother. She was able to provide me with the name and phone number of her cousin, who I will call later on this morning. But I do not believe that the family is going to be able to come up with that kind of a monetary bond. I'd ask for a $5,000 bond on each count.
Does Ms. Ford have any priors?
Just prior arrests, most of them were dropped, some traffic matters, and Your Honor, I apologize. It was a while ago that I read this. I mean, even more concerning, the report mentions after she pinned them against her vehicle the first time, she put the car in reverse, put the car in drive, and hit all three of them again. And this was corroborated by an independent witness.
Yeah, I know, I read the probable cause affidavit, Judge. I know that there's, it's not pretty. But,
Right, they're
Ms. Ford
the
is not going to be able to post that kind of a bond that the state's requesting.
I understand, but the allegations here are quite concerning. And so I do find probable cause. I am going to impose a bond of $10,000 on each count. And no victim contact until further order of the court.
All right. I will contact your family, Ebony, okay?
Okay.
All right. Is Alexandria Isaac still on medical loan? Yes.
I have one moment. I would have no objection to the court addressing bond at this time.
On who?
Ms. Isaacs, I know she's not here, but frankly, she's being held on a no bond hold for magistrates, and she doesn't have the ability to post bond.
It is no, oh, there's no bond. Right, what is the state seeking, or,
Your Honor, let's read over the allegations real quick.
this is something that happened at a hospital. Or is there anything else that's holding Ms. Isaacs? Or
Just
she
this case.
Just this?
Your Honor, I'm going to be requesting a $5,000 bond. There's the allegation that she punched and knocked a emergency room nurse unconscious. From my notes here, I'm showing she has an open battery out of Miami. A couple prior battery on law enforcement officers. This one from 2017.
Do we know if there are any mental health issues
I don't
or previous, yes. That's the one that, right, the mother was here earlier this week. Right. I think, okay, so this is the one where the mother was here earlier this week. There is mental health issues.
Yeah, and obviously it can be addressed, if she's unable to post, it can be addressed at another time.
Right.
But not dealing with it now is an absolute certainty that she can't get out of custody.
Right. I'm gonna impose a $2,500 bond. Okay. I don't know if her mom was able to locate, she did express concerns about not being able to get in touch with her.
And there does appear to be a history, Judge.
Okay. All right, thank you. So it's a $2,500 bond. Thanks, everyone. Mr. Shade,
Yes, Judge,
I believe you want me to call your cases?
if you'd like.
All right, on page 9, Michael Gillen.
Mr. Gentleman, come on up, please. Michael
Dude,
Gentleman.
Mr. Gillen was supposed to be in community court yesterday. Unfortunately, this had a KPS attached to it, and he was picked up. Judge Barner wanted to let you know that he's doing what he's supposed to be in community court.
Is he supposed to be going back? Because
Right,
she did
Michael.
tell me that there were a few that were coming back that
Right,
are not to come back.
You're supposed to go back to community court next Wednesday. Do you understand that? Okay, do you want to continue to do that? Do you want to continue to go to community court?
Yes, sir.
Okay. Judge, this is a city of Hollywood case. It has nothing to do with community court. And it would be off of your time served.
Oh, so this matter is Hollywood.
This is Hollywood, right. He
Oh,
was
okay.
picked up on this charge, but still, you know, he's doing well. Judge Barnes wanted me to point that out.
Okay, okay.
So Michael, come to community court next week, all right? Come to community court in Fort Lauderdale next week, okay?
Yes, sir.
All right, so as far as this charge, which is a City of Hollywood matter,
Yes, Judge.
okay. So what does Mr. Gillen want to do with this case?
It'd be time served, Judge, and you plead no contest.
Sir, do you wish to resolve this matter? This is a City of Hollywood matter, not a community court matter. Do you understand that?
Yes, ma'am.
All right. The offer is adjudication and time served. Do you understand that?
Yes, ma'am.
All right. Please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. And Mr. Gillen, do you understand that do you need any more time to speak with your attorney?
No, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No.
And do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes. Do you understand that?
Yes, ma'am.
What plea do you wish to enter, Mr. Gillen?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, sir.
Thank you very much.
All right. What, Drewitz, Marvin Drewitz?
Yes, Judge, he's in main jail. Marvin Drewitz?
Is he also on page 9? 10?
Druids is approaching, Judge. Come on up, sir. He's coming up, Judge.
Okay.
Good morning.
Good morning, Mr. Drewitz. How are you?
I'm fine.
All right. You are before the court, sir, for 4 misdemeanor capias matters, and these are all municipal ordinance violations for open container beverage in public. Well, and the fourth one, 3, and the fourth one is unlawful assemblies. So I find probable cause. Mr. Drewitz, what do you want to do today with these matters?
Hopefully they'll be dismissed.
Well, they're not going to be dismissed, so what's your next request?
Suggest.
Huh?
CTS.
Suggest.
Credit time served. I got it.
Busy man.
All right.
Acronyms.
All right.
Mr. Drewitz, Judge, I can tell you, is on the cusp by the city of Hollywood as to whether or not they'd give him a time served offer, but maybe because the CTS request, we'll do it today.
All right. So, Mr. Drewitz, today you have 4 of these violations from the city of Hollywood, and they're offering time served to resolve your case today. But basically what your attorney is saying is that if this happens again, the city of Hollywood may not make that offer. Okay? And so you've got to understand, I don't know What the exact location is that is it always the same place? I don't know.
It's the beach area.
But you need to make a change, is basically
Yes,
what I'm
ma'am.
saying, okay? If you keep getting arrested for the same thing over and over, that doesn't make any sense, right?
Right.
So you're gonna have to try and make a change.
All right.
All right, but
I will.
all right, well, I'm gonna remember that you said
Yes,
you're gonna try
ma'am.
and make a change, okay? All right, so you wanna resolve your case today, the sentence is gonna be adjudication and time served. Do you understand that?
Yes, ma'am.
All right, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Do you need any more time to speak with your attorney?
No,
Are you under the influence of drugs or alcohol?
not whatsoever.
All right, and you understand that you have the right to go to trial, but by taking a plea today, you're giving up that right.
All right.
And if you are not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes. Do you,
All right.
okay? What plea do you wish to enter?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. And Mr. Druids, one more time, you're gonna have to make a change, okay?
Yes, ma'am.
All right, good luck.
Thank you.
You're welcome. Franklin Fuller on page 10.
He's approaching, Judge.
How you doing?
Good morning, Mr. Fuller. This is a municipal ordinance violation for possession of cannabis. The court does find,
Yes.
the court does find probable cause.
Time served.
Time served from, is the offer?
Yes, Judge. Mr. Fuller, just understand that by taking this plea, it's a withholding of adjudication, it does not affect your driver's license, okay? Is that what you'd like to do?
So it's a withhold adjudication?
Yes, Judge.
Okay.
Yes.
All right, Mr. Fuller,
Yes.
do you wish to resolve your case today?
Yes.
All right, sir, as best you can, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Mr. Fuller, do you need any more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Is anyone forcing you to resolve your case today?
No, ma'am.
And do you understand that you do have the right to go to trial, but by taking a plea today, you're giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, sir? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is withhold adjudication and court costs. Good luck, sir. Angel Bilch?
He's approaching, Judge. He's here on me.
Okay. Page 12,
Mr. Bill.
thanks.
Approaching, Judge.
All right, sir, you have three misdemeanor capious matters. 2 are state charges and 1 is a municipal ordinance violation. They're all for trespassing. The court does find probable cause. What does you wish
Judge, in
to?
speaking with Mr. Belche earlier today, count 1 is the state offense. He wishes to resolve the matter.
Okay,
Judge, for the time, there'd be time served for the city of Hollywood as well.
okay,
One moment, Judge.
sure.
Judge, in speaking with Mr. Belche, if the offer is a time, sir, he wishes to accept the offer.
Yeah, that was, I'm waiting for the state's offer.
Adjudication, court costs, no return to 1601 North Federal Highway in Hollywood.
Okay.
Judge, he wishes to accept the state's offer.
All right. Sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, sir. You can put your hand down. Do you need any more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
Are you understanding everything that's going on here today?
Yes, ma'am.
You understand that you have a right to go to trial, but by taking a plea today, you are giving up that right?
Yes, I do.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you are not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am, I understand.
All right, what plea do you wish to enter?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given. Your sentence serves adjudication and time served, and also no return. Mr. Linder, what's the location again?
1601 North Federal Highway in Hollywood.
Okay, did you hear that, sir?
Yes, ma'am.
All right, no return to that location, good luck. Yes, yes. All right, then let's go back to our regular order. Mario Gillen.
Mr. Gillen is approaching, Judge. He's here. Man, come on up, sir. He has private counsel, I believe, Gabrielle Novo.
Okay. Well, Mr. Gillen, did you, when did you speak with your attorney?
I spoke with her office this
Oh, you
morning, Your
did?
Honor. She cannot be here today, but I did advise her that Mr. Gillian has a court date tomorrow morning at 8:30 in front of Judge Lynch, and her office indicated that she will be here for him at that time tomorrow morning.
Okay. All right, so Mr. Gillen, your attorney's office was contacted and they are not going to be here today, but they'll be in court with you. You do have a hearing tomorrow, okay? All right, today you're before the court for a violation of probation, which is, that has a no bond hold. And then count two is a violation of pretrial release, okay? So the court does find probable cause and, as you heard, you do have court tomorrow. Does anyone wish to be heard as to the bond on count two?
Yes, yes.
Yes. All right, that's the one that is before the court today. It appears.
For, violation of the conditions of pretrial release.
Right.
He's, what case do you have him on pretrial for, Michelle?
The 180120510.
Right,
I
that's
also
what,
have him on pretrial for 1812051 CF10A.
oh, that, on the one on the docket is for the, for today is 1801251 CF10A.
Yeah, he's on pretrial for charges.
No, I know the officer wrote that down, that's not this case number. The officer wrote down that case number because that's the case with the release condition he's violating.
Okay, so there's something else, there's another,
Yeah, what happened was, Your Honor, he was arrested for false imprisonment and battery.
right,
He was placed on pretrial with GPS. He was ordered not to have any contact with the victim, who's mentioned in this case.
yes,
That case number is 1812051 CF10A. This new charge, count two, is case number 194304 MM10A,
okay,
the violation of the no contact order.
okay. All right, so which one? All right, so as the bond on, on the count two,
Your Honor, I'm going to be requesting a $5,000 bond, noting that the underlying case involves allegations of false imprisonment and battery. If the court is not inclined to grant the grand pretrial's motion and hold him no bond, then I would ask that he be placed with a GPS monitor in this case as well, considering that I believe he was placed with a GPS monitor on the 2018 case.
All right, but he was, on this one, he was on a GPS monitor?
Correct, Your Honor.
Okay.
And just so the court's aware, there was actually a motion filed by the defense last year to delete the GPS monitor, which Judge Cohen denied.
All right. All right, Mr. Gillen, in either case, you're gonna be before your division judge tomorrow, but, these are all related charges. So as far as the pretrial supervision on case number 18-012-051 CF10A, I thought we said it was for the 19 case.
The violation?
Yeah.
The violation's for the 2018 case.
Okay, all right. All right, so on that case, the charges are false imprisonment and battery, and at this time, the court is going to revoke your pretrial release, grant the request, and I'm gonna impose no bond holds
Thank you, Your Honor.
on both counts. And then as to the new arrest, the violation of probation is already a no bond hold, and I'll impose on count 2 a $5,000 bond. All right, Mr. Gillen, good luck. Fairly Brownlee,
Mr. Brownlee is here, President Main Judge. He's approaching. Come on up, sir.
all right, sir, you are before the court this morning for robbery with a firearm. Count 2 is aggravated battery with a deadly weapon. Count 3 is selling cocaine. Count 4 is a misdemeanor capias. And count 5 is a felony violation of probation, and that has a no bond hold attached to it. And you do have court tomorrow on the felony matters, and then on Monday on the misdemeanor capias. The court does find probable cause.
Judge, our first question is in reference to count 2. 1 and 2, I see they're not in custody capiases. When were the date of offenses on those cases?
October 12th of last year.
Judge, I believe on counts 1 and 2, he's, at this time, if the state's not making any motion, he is entitled to a bond on those 2 cases. I'd ask the court to set a reasonable bond, and also on count 3, I believe, the bond is currently set at $150,000, and speaking of Mr. Brownlee, that's something that he's not gonna be able to afford. He's 24 years old, been here his whole entire life. He's self-employed. He does landscaping for a living. He's been doing that for about 2 years now. He makes $100 a day doing that. He lives locally here in Hollywood with his grandfather. His grandfather is the only person that's going to be able to help him out monetarily, and he's on Social Security. So, Judge, I'm going to ask you to take that into consideration in determining reasonable release conditions for Mr. Brownlee.
Your Honor, I'm going to be asking that the court impose a bond of $75,000 on count 1 and count 2. I'm going to be asking that the court keep the bond that Judge McCarthy set in place and all the special conditions that she ordered in place that are listed there in the on the warrant. On count 1 and 2, in that case, I'm going to be also asking for obviously no victim contact, no possession of any firearms or weapons, and pretrial release with a GPS monitor. Your Honor, I do believe Mr. Brownlee, and also a no contact order on count 4. That's an issue summons capias that Judge McHugh ordered, and the victim's name in that matter is Ashley Hampton. Your Honor, I do believe Mr. Brownlee represents a danger to the community based on both of the cases, the felony cases before the court. In the attempted robbery case, he's accused of not only attempting to rob the victim, but he and 2 co-defendants, where charges have been filed, armed themselves. Mr. Brownlee not only discharged the firearm, but shot the victim in his arm. Combining that, Your Honor, I can tell you on the delivery of cocaine case, and as an officer of the court for bond purposes only, I spoke with Detective Joshua Brasso from the Hollywood Police Department. I've also spoken in the past with Detective Kastner. They would be here this morning. They were not notified that Mr. Brownlee was picked up. They had to execute a search warrant this morning, so they could not be here. But they did ask me to relay to the court that they have great concern for the community in Hollywood with regard to Mr. Brownlee. Drug dealing in this community where this is occurring has become it's become an epidemic in this area, especially around the convenience stores. And I will leave it at that since they're not here to testify, Your Honor, but I would be asking that the court impose the bond and release conditions that the state has requested.
All right, Mr. Romero?
Judge, like I said, I believe now the total request from the state is $300,000. That doesn't change my prior argument. He's only working in landscaping, Judge. I mean, from what he gets paid $1 a day, he's probably going to have to work many years in order to come up with that bond. So, Judge, right now I just ask you to take his financial resources into consideration.
All right, as to the arrest warrant, as to count 3, Judge McCarthy did, set the bond for $150,000 with special conditions. So, as to count 3, I'm gonna leave that in place and, all the special conditions apply. And there it says bail may only be modified by the trial judge to whom the case is assigned, or the chief judge. Defendant shall secure his release pursuant to a surety bond that is fully collateralized. Defendant shall surrender any passport to the clerk of court prior to release. Defendant shall submit to home confinement with electronic monitoring, and the defendant shall not possess any firearms. I don't think I read the first one. Defendant shall not be released on bail until proof that the funds being used for bail are not tainted by illegal activity. So, those conditions were attached to the warrant, the arrest warrant on the selling of cocaine. So I'm leaving all those conditions in place. Finding probable cause, I am also going to, impose a bond on counts 1 and 2 for $50,000 as to each count. No firearms, no victim contact.
You said 50,000 for count on 1 and 2?
Yes. Okay.
And
Just for clarification purposes, so we're gonna put that, because she has lines. So we're gonna put that in Nebula, the surrender passport, firearm, and
I don't have anything with lines.
Your Honor,
What I read was all the conditions that she's put her initial to.
and if I may, just for record purposes, I'm familiar because there's been about 30 co-defendants as part of this.
Okay.
Co-arrestees. What happened was, if you notice, on the bond, you see how she originally wrote no bond and then scratched out and wrote
Yes,
150?
yes.
She originally put lines through the Nebula and full collateralization because there wasn't gonna be a bond. When she decided to set the $150,000 bond, she put her initials second. She didn't cross the line through, but I'll prepare an order for the courts because that's what the judge
Okay,
required.
all right. All right, I assumed that was just her initial. I didn't realize that. Okay.
Your Honor, is the GPS gonna be on both cases?
Yes.
And and for record purposes, Is the court ordering
No.
no contact on the domestic violence case?
Yes, whatever, 4, which one is that, 5? Or
4.
4. And let's, okay, all right,
Thank you, Judge.
okay. Michael Parrish,
I believe that's still reset.
medical loan. Parrish, Michael Parrish is a medical loan. Joseph Chirono Gatto,
He's approaching, Judge. He's here at me.
all right, sir, you're before the court for misdemeanor KPS. The charges are unlawful sticker and temporary tag violation. What does Mr. Gatto wish to do?
That's a judge. Judge, my understanding is, Mr. Judge, he's been in 7 days. He was being held on other matters. He's already seen his felony judge release him on level 2 Elmo.
Okay,
Gonna be asking you, since he's gonna be supervised on a felony offense on level 2 Elmo, on these two, cases, an ROR on these two matters, Judge.
okay. All right, the ROR will be granted on, as to these 2 counts. ROR. Richard Gabrielle,
North Broward.
Mr. Gabrielle, you're before the court on 3 misdemeanor KPS matters. Battery, resisting without violence, and possession of cannabis. And the court does find probable cause. These are both no-show KPS. I am going to leave the bonds in place, and you do have court tomorrow before your division judge.
Judge, based on my conversation with Mr. Gabriel earlier this morning, he indicated to me that he believes his father can assist him and his brother can assist him in posting bond. But he did ask me if the court would consider RORing him on counts 2 and 3. He believes that would make it a little more feasible for his family to bond him out.
Your Honor, he's gonna see his judge tomorrow morning if he doesn't bond out. And I would also note,
Yeah, I am not inclined to reduce the bond. He didn't
All right,
show
I'll call your
willingness,
family, Richard.
okay?
All right, thank you.
All right, good luck, sir. Juan Mera Garcia,
Judge, I've been advised he's in court.
okay. All right, so Mr. Garcia's in court. I'll have to reset Mr. Garcia. Teddy Millen,
Mr. Millen, come on up, please. He's here.
all right, Mr. Millen is before the court for a violation of a misdemeanor matter, violation of probation on a misdemeanor matter for petty theft. And Judge Hurley did set a bond for $2,500. I don't know when he has court. Do we know? All right, I'm gonna leave the bond in place and he'll see Judge Hurley. Curtis Hunter,
Mr. Hunter, come on up, please. He's here at me.
all right, Mr. Hunter, you're before the court for trespassing, and the court does find probable cause.
Judge, and speaking to Mr. Hunter earlier today, he wishes to resolve this matter.
Okay,
One moment, Judge.
okay.
Your Honor, the state's offered be adjudication 5 days in county jail. I note, as far as state priors, he had 4 separate trespasses last year, and I am concerned, according to the report, he told the arresting officer that he would return to the address and knock out multiple vehicle windows. I would also note that body-worn camera was in use.
Judge, and speaking to Mr. Hunter, I do realize in speaking to him, he does have prior trespasses, but from my,
That's on the shelves.
okay, but from my understanding and just speaking to him right now, I believe this may be the first time he's been trespassed from this actual location. And if that's correct, Judge, I'd be inviting the court into plea negotiations, and I'd ask the court to consider extending an offer of time served on Mr. Hunter's behalf.
Last time he was arrested, and that was on a capias for a trespass, the arrest location was 1700 Northwest 30th Avenue.
No, the report does say that, he was warned not to trespass on the property.
Judge, he advised me he was arrested at that location, but he wasn't trespassed. He was actually arrested at that location before.
All right, there seems to be some issues, and this is first appearance, so I'm going to leave the bond in place, and then Mr. Hunter can speak further with his attorney to resolve this matter. Jeffrey Cooney,
Cooney, bonded, Judge.
okay? Edison Gomez,
Medical reset, Judge.
okay? John Charland,
Mr. Charlin is here. Mr. Charlin, come on up, please. He's approaching, Judge.
Mr. Charland is before the court for trespassing, and the court does find probable cause.
Judge, and speaking Mr. Charlin, he wishes to resolve the matter today.
Okay,
I don't have an offer, Your Honor. This involved his father's home.
Judge, and that's what Mr. Charlin advised. I told him there probably may not be a plea offer from the state. Having said that, Judge, considering this is trespass offense, my understanding the last time he got in trouble with the criminal justice system was back in 2008. So I'm going to be asking the court to consider releasing him ROR.
I'm gonna deny that. If Mr. Charland, I'll release him to pretrial supervision.
Yes, Judge.
Okay.
I just asked for an order of no victim contact, Your Honor.
Mr. Charland, the paper that the attorney is handing you, gives you the directions to pretrial supervision. Within 24 hours of your release, sir, you must report to pretrial. Failure to do so, a warrant will be issued for your arrest. Further, I'm imposing a no victim contact, which means that you are not to be found anywhere near I believe the alleged victim here is your father. So no return to the location, no phone, no text, no social media, no asking anyone to contact him on your behalf. Do you understand that, sir?
Yes.
All right, good luck, sir. Nelson DaCosta,
He's approaching, Judge.
Mr. DaCosta, you're before the court for a traffic KPS matter. Failure to register vehicle. The court does find probable cause. What does he wish to do?
Judge, Mr. DeCosta wishes to resolve this matter today.
Okay.
And the offer from the state is withhold court costs.
Okay.
He wishes to accept the state's offer, Judge.
All right, Mr. DaCosta, do you understand the offer?
Yes.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. Do you need any more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No.
Is anyone forcing you to resolve your case?
No.
And do you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. And your sentence is withhold adjudication and court costs. Good luck.
Good luck, sir.
Robert Cortez,
Conti, Your Honor.
thank you.
Thank you.
All right, Mr. Cortez, you're before the court, improper exhibition of a dangerous weapon, and count 4. Is it 2 and 4? 4 is
Yes,
for
ma'am.
criminal mischief.
Yes. Your Honor, bonds were originally set at $1,000 and $500. I'm showing that Mr. Cortez also has a no bond VOP hold and over $10,000 worth of bonds out of Pinellas County. I'm requesting that the original bonds be placed back on these charges.
So the original bonds were how much?
$1,500.
The state is correct, Judge, and that would be fine.
Okay.
He does have a no bond hold.
All right, so I'll impose a $1,000 bond and a $500 bond on count 2. Okay, good luck, sir.
Thank you.
All right. Marvin Desir,
Judge, he's approaching here at me. He declined the services of public defense.
is he represented by the public defender on other counts?
No, Your Honor, he has a private attorney. His name is Sean Clayton. I spoke with Mr. Clayton's office earlier. I think they're sending somebody by, but I wasn't really clear on that. I did tell them that he has a no bond hold and that he has court tomorrow morning. So I don't know if anyone from their office is coming by.
All right, well, they didn't expressly say someone was coming?
They were working on it.
Okay.
But they do know that Mr. Desir has court tomorrow.
All right, Mr. Desir, you are before the court. Charge number 12 is defrauding a financial institution. 13 and 14 are felony violation of probation matters, and those 2 have no bond holds. You do have court tomorrow on your felony matters, and the court does find probable cause as to count charge 12, and your bond is $3,500 on that charge, okay? All right, good luck, sir. Rocky Blythe,
He's in Maine.
Mr. Blythe is here present, Judge of Maine. Good day, Your Honor.
good day, Mr. Blythe. You are before the court, and now these are additional charges. 6 is petty theft, 7 is petty theft, 8 and 9 are bond surrender of your felony bonds. The court does find probable cause.
Your Honor, I'm going to request that the court keep the 2 $750 bonds in place. The total bond on all of his other charges is $6,350, and the other 7 charges are all theft-related.
Okay,
Judge, that is correct. He has other matters which he has a bond of what the state just advised. He's still in custody. That shows and that confirms what he told me financially. He can't afford to post anything. He's been in custody, I believe, since about Friday. He's been living here in our community his whole entire life. He lives here locally in Pompano Beach. He's trying to work. He's a barber, but unfortunately he has no savings to post a monetary bond. He wanted me to relay that to the court and advise you that he can't afford anything. He wanted to know if this court can do anything for him to have him released so that he can continue working and basically not risk losing his job.
Well, on 8 and 9, those counts are not for magistrate. He's got $1,000 on each count. So the bonds are gonna remain in place at 6 and 7, 750 on each, those. All right, Dustin Wiggins,
Mr. Wiggins, I've been advised, is in court, Judge. He's in room 5155.
all right, so we have to reset Mr. Wiggins. Alex Sherlock,
Is he right above us?
all right, Mr. Sherlock, you are before the court. Count 1 is a violation of felony probation. There's a $500 bond that's been attached to that. And then on count 2, you do have an out-of-state felony hold. That is a no bond hold. And that's out of the state of Georgia. So you have court on your felony matter tomorrow, so I'm leaving the bond in place. And then you have to go to also extradition court. Good luck, sir. Michael Nelson,
He's approaching, Judge.
all right, Mr. Nelson, you're before the court for a charge of burglary, occupied dwelling, unarmed. All right, the court does find probable cause. All right, does anyone wish to be heard as the bond?
See if the defense is prepared, please, by all means, Mr. Romero.
Judge, and speaking of Mr. Nelson, we're going to be asking for a $3,500 bond. He's 35, been here his whole entire life. He was working. He unfortunately just lost his job. He was working at the Komodo restaurant, where he was employed there for about 8 months, making about $10 an hour, I believe, as a dishwasher. He lives locally here in South Florida, in Miami, with his sister. Where they rent the house that they live at. The rent is approximately $1,000 per month. Now, his sister, she lives at the house with her 2 children, so her financial resources are limited because she's taking care of her children. Now, he will be reaching out to his girlfriend, but unfortunately, her financial resources are not better. She's actually on disability and cannot work. So he's hoping that his girlfriend, along with his family, can pull their resources together, and maybe they can come up with a bond if the court were inclined to set a bond around $3,500, and that's what we're requesting.
I'm sorry, what are you saying?
His sister is present, Judge.
Okay. All right, does she wish to, ma'am, do you wish to be heard? No. Okay,
Based on my conversation with her, Judge, if I could have just 1 second.
sure.
Mr. Nelson's sister indicates that she would be able to make the bond as requested by Mr. Romero.
Okay.
Your Honor, I'm going to be requesting a higher bond. I am concerned. I'm going to be requesting a $20,000 bond with a GPS monitor. And I would note, Your Honor, he was placed on 5 years probation by Judge Shear for burglary of a dwelling on April 16th.
Of when? What
This
year?
year.
Of
What's-
this year?
Yes, but what's concerning is, Your Honor, he pled the case out May 9th of last year, and sentencing kept getting put off for almost a year. But what that means is that he committed this burglary, according to the allegations, while he pled out to a burglary of a dwelling and was awaiting sentencing. I imagine it wasn't ever brought to Judge Shear's attention because this is a not in custody. It looks like, I don't know what was known at the time as far as his identity, but it is obviously, and I know the defense may argue that, well, he's on supervision now. Yeah, but the prospect of the flip side to that is that he committed this while he was awaiting sentencing. And if that isn't enough of a deterrent, then I don't know that a violation of probation is enough of it, would be a deterrent.
All right. From everything that this court has heard this morning, it is concerning, and there is cause for concern for the community. The allegations are that he was caught on surveillance video in the victim's backyard, that then he returned with an accomplice, and then they were able to get into the victim's bedroom, through the victim's bedroom window, and then later seen leaving with a blue blanket that came from the victim's home filled with personal property. And also the fact that he was awaiting sentencing on another matter. The court does find probable cause, and I am going to impose a $10,000 bond on this case. I'm also going to include a level 2 GPS. All right, so no victim contact, and he'll be on level 2 GPS as well. Good luck, sir. Thomas Kiblin.
Approaching judge.
Thank you.
So is it supposed to be 2 parole violation or 1? So no violation of probation? No. Okay. All right, so what are we gonna do? Are we writing that in and crossing anything out? What are we
Yes, we
doing?
could just cross out, put a line.
Sheila, I need to ask you something real quick.
All right, Mr. Kiblin, just so you understand what's going on over here, there was a probable cause determination sheet that was provided to the court that said that you have 2 felony violation of probation. Confinement status is correcting that. It is not a violation of probation. It is a parole violation, 1 parole violation, okay? So you will be going before the parole board on this matter.
I might have passed it on.
All right, good luck, sir. Giovanni Lombard. Giovanni Lombard.
Mr. Lombard, declined the services of public defender.
All right, Mr. Lombard, you are before the court. Counts 1 and 2 are misdemeanor KPS matters. Counts 3 and 4 are felony violation of probation matters. Those are both no bond holds, okay? On count one, there's a bond of $25. Count two, you've been ROR'd. You do have court tomorrow at 8:30 on the felony matter. So the court finds probable cause and you'll see your division judge tomorrow. Good luck, sir.
Okay, thank you.
Lancelot Brown,
Lancelot Brown? He's coming? Judge, he's on his way.
okay?
Come on up, sir.
Okay, Mr. Brown, you have a misdemeanor capious matter, and you also have a felony violation of probation matter. So, the court does find probable cause. The bond on one is $100, and you do have court tomorrow with your felony division judge, and then on Monday on the misdemeanor matter. Good luck. Jason Douglas.
Mr. Douglas, come on up, please. He's approaching, Judge.
All right, good morning, Mr. Douglas. You are before the court for a felony violation of probation. That is a no bond hold. And count two is a hold for the U.S. Marshal's Office. That's also a no bond hold and not for magistrate. As to your felony matter, you do go to court tomorrow at 8:30. Good luck, sir. Stephen Caputo.
He's approaching, Judge.
Mr. Caputo, you're before the court for a felony violation of probation matter. That's a no bond hold, and you'll be before your division judge tomorrow at 8:30.
Good luck, sir.
Ray Ward.
Mr. Ward is here present at main, Judge. He is approaching. Come on up, sir.
Go ahead. Go ahead.
Judge, we're going to be waiving formal reading of the charge.
Okay, the court does find probable cause. And I'll hear from the parties as to bond.
One moment. Your Honor, the state is going to be seeking a $100,000 bond, pretrial release of the GPS monitor, no victim contact, no contact with minors. Your Honor, I believe these, I'm very concerned by these allegations. I would note Mr. Ward has 11 prior felony convictions. He has gone to state prison in the past. One moment, Your Honor. Nothing further, Your Honor.
Okay.
Judge, from what this data suggests, that's something that Mr. Ward's not going to be able to afford. I do realize from what the state said, he has prior contact with the criminal justice system, but my understanding is speaking to Mr. Ward, those are all quite dated. He informed me he's been clean ever since 1992. So it's well over 20-plus years. Judge, he's been living at the same location now for about 7 years, which is here locally in Fort Lauderdale, and his monthly rent is about $500. He does collect Social Security, and his source of income is approximately $751 per month. Now, he does have family that resides in our community. His sister, who I'm going to be contacting after court, but from what he told me, her financial resources are quite limited as well. She is receiving retirement, so I don't think she'll also be able to afford what the state is suggesting. I'm going to be asking you to take into consideration Mr. Ward's financial resources and determining reasonable release conditions on Mr. Ward's behalf.
I just want to make sure I didn't mishear. I believe Mr. Romero, and please correct me if I'm wrong, I believe Mr. Romero represented, and I imagine this is what Mr. Ward advised him, that he's been clean since 1992.
That's true.
Okay.
That's what he told me.
These are the following offenses that he's been convicted of since 1992. 2004, possession of cocaine. 2004, possession of cocaine. 1999, possession of cocaine. 1999, burglary of a structure, resisting without violence. 1995, delivery of cocaine, 24-month state prison. 1995, burglary of a structure and grand theft with a violation of probation, 24-month state prison. 1995, burglary of a structure, grand theft with a VOP, 24-month state prison. 1994, burglary of a structure, grand theft, possession of burglary tools, resisting without violence. 1993, possession of cocaine, resisting without violence.
All right, the court does find probable cause, and there are, the allegations in this affidavit is quite alarming and concerning, and the court finding probable cause, I am going to impose a bond of $100,000 with GPS, no contact with minors, no contact with the alleged victim in this case.
Michelle, you got the next one. You got the next one.
Okay. Conrad Alls.
Come on up, sir. Mr. Alls is here, Judge.
All right, Mr. Alls, you are before the court for one count of grand theft. And the court does find probable cause.
Your Honor,
Yes, ma'am.
Mr. Alls was just in court on April 20th, 2019, case number 19005105 CF10A. Petty theft, the second degree, third or subsequent offense. He was placed on pretrial. At this time, we're going to request a revocation of his supervision.
And Your Honor, just so the court has a full picture of what's going on, the case he was put on pretrial, he was actually arrested on the 19th of April. Before that, he was arrested April 11th on a theft. He was county sentenced. It looks like he was sentenced to 5 days and was released April 16th. So this would be his third arrest in the past 2 weeks for theft.
All right, Mr. Alls, you were on pretrial supervision without the need to post a bond on a felony matter. The pretrial services is asking that your bond be revoked, your pretrial supervision be revoked, and I am going to grant that motion, and you will be held no bond on that case.
Thank you, Your Honor.
And as to the new arrest, your bond is $1,000. Court does find probable cause. Aiden Alexander.
Approaching, Judge.
Mr. Alexander, you're before the court on a felony violation of probation matter. This is out of Leon County, and it's a no bond hold. And All right, so the court does find probable cause, and you should be going, I don't know when Leon County is gonna pick you up. All right, good luck, sir. Joel Melendez,
He's approaching, Judge.
all right, Mr. Melendez, you are before the court. Count one is deliver cannabis, less than 20 grams. Count two is possession of THC. Count three is possession of alprazolam. Counts 4 and 5 are felony violation of probation. Those are both no bond holds. That's out of Orange County on the violation of probation matters. So the court does find probable cause. Does anyone wish to be heard?
Nothing from the state, Judge.
All right, so the standard bonds are in place on counts 1 through 3. Good luck, sir. Mark Fenelon,
He's approaching, Judge.
Mr. Fenelon, you're before the court for count 1, criminal mischief, and count 2 is throwing a missile into a vehicle. The court does find probable cause. Does anyone wish to be heard?
Your Honor, I'm going to be requesting a $7,500 bond on count 2, no victim contact. First, based on the allegations that he smashed out the victim's windshield while she was in the vehicle. This after he was attempting to break her driver's side window with concrete. I would also note he's currently out on $10,000 worth of bond before Judge Siegel on charges of possession of cocaine with intent to sell or deliver at or near within 1,000 feet of a school, and possession of cocaine with intent to sell or distribute. His criminal history includes 2013 possession of cocaine, 2-year state prison, 2012 sale or delivery of cocaine at or near a park, 2-year state prison, burglary of a dwelling, 2010, 23-month state prison, delivery of cocaine, 07, 23-month state prison. Those are his most significant priors, Judge.
Judge, I apologize. I didn't hear what the state was suggesting as far as a bond amount on count 2.
$7,500.
Judge, I'm going to be requesting a $2,500 on Mr. Fenelon's behalf. He's been here his whole life. He's working. He works for a company called Solar One. He's been there for about 5 months, making about $12 an hour. I imagine I imagine the PC affidavit indicates that he was basically arrested in front of his residence. This occurred in front of his residence, in which the victim came to seek him and harassed Mr. Fenelon. So that would be litigated later on. So it's not like Mr. Fenelon went to seek the victim out. It was the other way around. So I'm going to ask you to take that into consideration in determining reasonable bond for Mr. Fenelon.
All right, as to count 1, count 2, I'm going to impose a bond of $5,000. All right, good luck, sir. Matthew Toro Botero,
North Broward.
North Broward, Your Honor, he refused to attend.
oh, okay.
I heard you.
All right, Mr. Toro Botero refuses to attend. The charges presented are trafficking synthetic cannabinoid and possession with intent to sell, manufacture, or deliver cannabis. And the court does find probable cause, and the standard bonds, $15,000 and $5,000 are. Brian Lamar Scott. Okay.
Judge, he bonded.
Yes, thanks. Michael Garbars.
North Broward.
Approaching.
Thank you. All right, sir, you are before the court for possession of controlled substance without prescription. Count 2 is resisting officer without violence. Count three
I was
is,
trying to destroy the evidence, that's what it was. I
Michael,
had two
didn't
cans of
I
heroin.
just mention to you that you should not discuss the facts of your case in front of the court? Because everything you say is being recorded?
count three is trespassing, count four is tampering or fabricating physical evidence, and count five is a municipal ordinance for panhandling. And the court does find probable cause. And does anyone wish to be heard as to Mr. Garbas's bond?
Your Honor, Mr. Garbaz, from what he has told me, is in absolutely no condition to make any type of monetary bond. He has no money. He is obviously, as the court can see, wheelchair bound. He has problems with his hip. He has problems with his back. I know he has had some contact with the criminal justice system in the past. I think maybe some of the charges that he's currently facing are related to the physical injuries that he has. But he's not going to be able to make a dime's worth of bond, Judge. So I'm going to ask the court to consider putting him on pretrial release.
One moment, Judge.
Okay.
What is, I've heard of that before. What is that pretrial release? What is that,
It means
like,
you'd have, if the judge agrees to that.
that's not ROR, right? Or,
No.
It's not.
No.
like,
What
so
it
you're
would
next
entail
court
is,
date, or-
Michael, if
Yes.
you would have to report, if the judge goes along with it, and we're going to hear from the state whether they object in one moment, but if the court was to place you on pretrial release, you would have to report tomorrow to downtown Fort Lauderdale, check in with them, and then comply with what other conditions the court deems appropriate, whether you have to call in a couple of times a week or whatever the judge thinks is appropriate. But you wouldn't have to post a monetary bond. You wouldn't need any money to get out of jail.
2015. He was released from state prison 2015 on trafficking, and Your Honor, I'm going to ask if the court's inclined to place him on pretrial that there be random testing, and I just want to make sure he fully understands, because I know Mr. Reedy mentioned the phone calls. I imagine there's going to also be reporting physically as well, and I would ask the court if we can make sure he understands what's going to be required of him so he's not setting himself up for failure.
All right, Mr. Garbas, what they're asking me to let you know is that if I decide to put you on pretrial release,
So, man, what's going on?
you are going to have to report, first of all, within 24 hours of your release, you'll have to report to the pretrial supervision offices. Two, there are drugs involved, so you will be also placed on, there'll also be a requirement for random drug testing, which means you have to go to the pretrial supervision office to do that. And you also have to make phone calls to the office, to phone in, to check in. So, do you understand that?
Yeah, how often is this? I mean, like, how often do I gotta report in and stuff like that, you know? I've never been on that before.
Pretrial, is it 2 times a week is the minimum?
The minimum, yes, if the court wants it to fall more frequent, that's
The minimum requirement is two times per week. But then you also have to do the testing, so, you know, it's random.
You know, but I'll pass that shit up. I'm not gonna be sitting there under the gun, like I'm on probation.
Then I'd ask the court to leave the bonds in place.
All right,
So, what, I can't get ROR? till
No,
my,
sir,
next court date?
there will be no ROR. No, sir. And with that attitude,
No,
it appears
there's a lot
that,
of running around.
oh, well, I'm sorry to inconvenience you, but, you
No,
are,
I mean, physically, like you're saying, I don't wanna set myself up for failure.
oh, okay.
At the judge.
does sound pretty tempting, getting out of here in a day.
All right, that's not gonna happen today. So as to count one, your bond is gonna be $2,500, and then the standard bonds on counts 2 through 5 will remain. Good luck, sir. Reginald Lovett.
Mr. Lovett, Judge, is here at Maine, and he is approaching. Come on up, sir.
Sir, you're before the court. Count one is possession of cocaine. Count two is operating without a valid driver's license. And count three is parking in the handicap zone. That's not for magistrate. The court does find probable cause.
Judge, in speaking Mr. Lovett, I'm going to be contacting his mother after court to post his monetary bond, so nothing from the defense.
Okay, does the state wish to be heard?
No, Judge.
All right, sir, your bond is $1,000. Good luck. Deontay Lenton.
Mr. Lenton, come on up, please.
Sir, you're before the court for burglary, unoccupied conveyance, unarmed. The court does find probable cause. I'll hear it as to bond.
One moment, Judge. Michelle, do you have anything from other counties? Yes, ma'am. Yes, anything outside of Broward County. Your Honor, while I'm waiting for that information, I can tell you, he, as far as Broward, he had a trespass in 2017, a loitering and prowling in 2017, where there were allegations that he was seen looking into parked vehicles, pulling on door handles. He does, let's see. He has, let's see. um, six. Your Honor, he has 8 priors as a juvenile. So it does appear, unfortunately, this is Mr. Lenton's MO, breaking into vehicles as a juvenile, now as an adult. I'm going to be requesting a $7,500 bond, no victim contact.
Judge, years old. He's been here his whole entire life. I believe this is the first felony on his adult record. So as far as an adult, he has a relatively clean record. He was working in construction. Now what he advised me is he basically finished taking a class so he can be a forklift operator. That's what he wants to be. He lives in West Park with his father. His father, what he does for a living is basically loads and unloads trucks. He's going to be reaching out to both his father and his friends, and his friends are also working construction. So his financial ability is very limited. Considering this is a third-degree felony, Judge, and he basically has a clean record as an adult, I'm going to be asking for a $1,000 bond.
All right, the court does find probable cause. I am going to impose a $2,000 bond. Delphrey O'Leish, bond posted. Tyree Strong.
Mr. Strong, come on up. Judge, my understanding is he has the private counsel. I believe maybe my colleague just tried to get in touch with him.
Brian, Tyree Strong, senior attorney.
Yes, on Mr. Strong, Your Honor, I spoke with his family. They have not yet retained counsel, so they will be relying on the Office of the Public Defender to represent him this morning.
Okay.
And I'm sorry, Mr. Romero, I should have given you the heads up on that. My apologies.
Mr. Romero, are you ready or do you need a few moments?
I need a few moments, but I'm ready on the other gentleman.
All right, so will we call Mr. Strong? Dmitry Shebakov?
Mr. Shebakov is here present, Judge.
Good morning. Good morning. Mr. Shebakov's bond was posted? All right. So, Mr. Shebakov, you're before the court for grand theft, and I find probable cause, and I've been advised that your bond has been posted. Kadeem Clark?
Mr. Clark, come on up, please.
Mr. Clark, also you're before the court for possession of cannabis over 20 grams. The court does find probable cause, and I've also been advised that your bond has been posted. Ricky Rogers.
Mr. Rogers, come on up, please.
How you doing?
I'm well, sir. You are before the court for carrying a concealed firearm, and count two is possession of cannabis, 20 grams or less. The court does find probable cause.
Judge, I'm going to be requesting that the court consider releasing Mr. Rogers on pre-trial release. He's 21 years old. He's been here now in South Florida for 1 year. He is studying here. He is on a athletic scholarship here. He lives locally in where he also works. He works at a place called Grumpy Gary's, where he's a dishwasher making approximately $10 an hour. From what he advised me, he doesn't believe anyone can post his bond, so that's why I'm asking for him to be placed under supervision.
Yes.
Mr. Rogers currently has a warrant for failure to appear, driving while license suspended. It's right here.
Hardy County.
Which one?
Hardy.
Okay, with $1,000 fine.
Right.
I'll leave it in the court's discretion.
Hardy County.
Okay, in addition, out of the state of North Dakota, he was convicted.
All right, so where's Mr. Rogers in college?
ASA College, Judge?
What is that?
So, it's a junior college.
Well, what does ASA stand for?
I don't know the exact meaning, but it's a science academy.
It's located in Dania
It's
Beach.
located in Dania Beach.
ASA.
Well, I would think that if you're in school, you would at least know what the name of the school is. And he's got charges out of Dakota and then a Hardy County. A court finds probable cause. I am going to increase the bond on count one to $5,000. Okay. Yes, Arturo Murefiol. Mr. Field's bond has been posted. Michael McLeod. Is he still a medical reset?
Conti, Your Honor.
Okay.
He not a medical reset. He refused to come. He was in court yesterday.
All right. So this is count number 33 and 34 for grand theft and illegal use of credit card. I guess Mr. McLeod didn't want to wake up another morning to come before the
I
court.
don't blame him. Your Honor, I was just going to ask that the court keep the bonds in
The
place.
court does find probable cause and the bonds will be in place.
Thank you, Your Honor.
Thank you. Joel Valley?
North Broward.
All right, Mr. Valley, you are before the court. This is for a change of charge.
Yes.
Burglary, unoccupied dwelling, unarmed.
Yeah, it was upfiled from a burglary of an occupied structure. Bond was originally set at $5,000, Your Honor. I'm just requesting that it be kept at $5,000. I believe he has a no bond.
Yeah, Mr. Valley has some no bond holds, Judge, so
Right.
he
So
needs to go
Mis-
in front of his
So,
division.
Mr. Valley, you'll go before your division judge here. Your bond is $5,000, or still is $5,000. Good luck, sir. Marcus and Jenny?
North Broward.
Refuse.
Oh,
Did he?
Yeah, he refused.
Okay. I was just talking to him.
did you speak to him this morning, Mr. Reedy?
That was the wrong inmate.
Oh, it wasn't the right person that he spoke to?
Right, it was the wrong one. And then we went to get the right one, he refused to come.
All right, so, Mr. Jenny's before the court for burglary, unoccupied dwelling, unarmed.
And Your Honor, I can advise you, it's a change of charge.
It's a change of charge?
Technically.
Yes.
Your Honor, the information the state filed doesn't delineate between unoccupied or occupied. It just charges it as a burglary of a dwelling.
Okay.
Because either way, it's a second-degree felony. You originally said bonded $10,000 for the GPS. If you'd like to see the original probable cause affidavit, I think it's clear in its face, the victim was home, in her home, or his home, when this occurred.
Yeah, I read the probable
I
cause.
am gonna leave the previous conditions in place. 10,000 with the GPS?
Yes, ma'am.
All right, and so I think the only person we have left is Mr. Strong, when the parties are ready.
We're ready to proceed, Judge.
All right, Mr. Strong is before the court for one count of manslaughter, and the court does find probable cause. Tyree Strong.
Your Honor, the state is going to be requesting a $150,000 bond with pretrial and the GPS monitor. I'm making this request based on the allegations in the arrest warrant affidavit, the potential consequences Mr. Strong faces if convicted. As far as the allegations, just noting in my opinion, the extreme level of negligence shown in this case, where Mr. Strong was essentially playing with a firearm in the back seat of a vehicle directly behind the victim in this case, where witnesses observed him, and I quote, "He removed a handgun from a holster that was on his side. He removed the magazine from the handgun and began to compress the trigger of the weapon multiple times while the weapon's safety was activated. He then deactivated the weapon's safety and began compressing the trigger a second time. It is at that point that the firearm fired one round, striking the victim." I would note the strength of the evidence, Your Honor, that there were two witnesses to this incident in the vehicle. Both identified Mr. Strong as the person that shot the victim.
Okay, Mr. Romero?
Judge, I understand the allegations are quite serious. My understanding that Mr. Strong's family was talking to law enforcement where Mr. Strong arranged to basically surrender himself. He turned himself in, I believe, at the local law enforcement police station. Right now, before he was going to college. Unfortunately, that didn't work out, and now he's currently looking for employment. He's going to be residing with his uncle. His uncle lives locally in Miami. He's 21 years old. Now he is going to also be reaching out to his father, so hopefully his father and his uncle can come up with the monetary bond. My understanding, his father works at a warehouse. We have no objection as far as Mr. Strong being supervised, but the monetary amount is something his family nor him can afford. We're going to be requesting a $25,000 bond on his behalf.
Your Honor, I would note, Mr. Romero is correct. It's noted on the short arrest form that Mr. Strong was taken into custody at the Lauderhill Police Department. But I think it is worth noting, according to the affidavit, that after he shot the victim and one of the other passengers in the vehicle tried to render aid to the victim, Mr. Strong just walked away from the area. Well, there were two other individuals.
I believe Mr. Strong, it'll be shown in the future, he's the one that actually called the ambulance and the police.
All right, I don't know about those other things that are not presented to me today, so I have to go by the probable cause affidavit that has been presented, and this is just very concerning, but if the court does find probable cause, I am going to impose a bond of $100,000. That's going to be with GPS, with GPS,
It's a level 2, Judge.
level 2 GPS.
Thank you.
I'll call Mr. Woodward back for you, Mr. Strong.
And, Your Honor, I'm sure it goes without saying, but I just asked for the record. He also be ordered not to be in possession of any firearms.
No firearms, and this is just, it's just bad all the way around. No firearms.
Yes, sir.
Okay.
Okay, good luck, sir. All right, I think that we're at the end of our docket.